Good morning. We're going to get started here in just a minute. Good morning. Welcome to our 17th annual Fall Consumer Bankruptcy Conference. We've actually done 18 of these, but we've done them over 17 years. One year we actually did 2 in a year. I'm Paul Shale, a trustee for Chapter 13 trustee for the Northern District Hammond Division. And my co-host, Deb Miller, who's the trustee for South Bend, Fort Wayne, and soon to be Lafayette. On behalf of both of us, we want to welcome you here. This program's been approved for 6 hours of CLE credits. For those of you here in person, there's a sign-up sheet. When you come in and leave, you need to sign that. If you're here for the 6 hours, all you need to do is sign it. If you have to leave and you're not claiming your full 6 hours, please indicate on there when you leave how many hours you're claiming. And if you're not here for the ethics or something, please let us know that so we can send a certification in. I know we're close to the end of the fiscal year for CLE credit, so we'll try to get those reports in. For those of you attending virtually, there's a certificate of attendance in your materials. So if you would complete those and email them to me, it's the same email you use for registration, paul@pshale13.com, paul@pchael13.com. For those of you attending virtually, please send those. And again, either let me know the full 6 hours, or if you can't participate in the whole session, please let me know how many hours that you're claiming. If any of you need out-of-state credit, there's a certificate of attendance form out there at the registration desk. I can sign that for you to submit to any other state where you might need credit. And we're happy to get you a copy of the approval letter if that helps with another state. A couple other things. Out at the far end of the registration, there's a table set up with a computer screen. Jake Stoyer, who's my IT manager, is out there. We have revamped the website for our office in Maryville for the Hammond Division. There's a couple interesting features on it, and he's available to show that to you as well if any of you want to see what the National Data Center looks like so you can access information. He can show you that, talk about payment systems and things that are available. But one of the features that we've added to our website, because we have 3 different courts to cover and there's 2 staff attorneys and myself that are covering those, we have a scheduling page now so you can find out, for instance, next week, Monday, who from my office is covering the court call with Judge Ayler and who on Thursday would be covering with Judge Lindquist or Judge Singleton. So that's something now when you want to communicate with us about cases you have coming up on your calendar, you don't have to copy all 3 of us. You can communicate directly with tour of that. He'll also show you the button, and we're not fully approved yet to implement it, to do Zoom 341 meetings. Deb Miller's already been doing those for some time. I think there might be some movement by the U.S. trustee eventually to make that as a permanent option. We've got ours set up and ready, but we're waiting for a few steps to be finally approved, and then we'll turn that on. But he can show you how to access that and how to have your clients access that Zoom site. So when that's ready to go, in the meantime, we'll continue to use telephone. Lunch will be served right at your tables. Like it was last year. For those of you who were here last year, you should have a card, and if you put that card out, they'll come collect those at some point so they know what meal to bring you. And I think that's the rest of that will take care of itself at the lunchtime at noon. We would ask all of you to silence your phones, and if you do get a call that you need to take, please go out into the common area and take the call out there so it doesn't disturb the other attendees. We understand things have to happen. There is Wi-Fi access. The broadband is not quite as vigorous as we would hope. Our second presentation is coming in, the U.S. trustee presentation is coming in by Wi-Fi, so if you could kind of refrain using it until after that. Also, if you could refrain using anything that's a big bandwidth hog, like a video or something, that would help. The Wi-Fi is mpac.prod. If you look at your Wi-Fi to see what comes up, mpac.prod for productions. And then the password for that is Showtime, all in small letters. But please don't use it if you don't need to, and please don't do anything that's going to hog the bandwidth that'll interfere with our ability to deliver the seminar. We would like to recognize a number of members of our bar. First and foremost, Judge Dees, who's just retired. Judge Harry Dees has been on the bench here a long time. We were hoping he'd be able to drop by this morning, but I don't think that's going to be possible. But we certainly enjoy his many years of service to all of us. Most of us that got to practice there found practicing in front of him was always a pleasure, and we're going to miss him. Also, Trustee Gordon Gavaya is going off the panel. Trustee Greg Boyer, I think, resigned about a year ago as a trustee. Trustee David Rosenthal, the Chapter 13 trustee down in Lafayette, is retiring at the end of this month. Deb Miller will be taking over those cases. And Lorraine Troyer, who is here, I understand, is going to retire soon. So at least that's everybody I know of. And we're happy for all those that are retiring. On a sadder note, we've lost 4 of our members over the last year. Trustee Dick Ransel, who regularly came to this conference, passed away. Attorney Kevin Schmidt, who also regularly attended and was a presenter a few times. Attorney Drew Redd from Chesterton, and also Dave Redding, who was also a regular attendee at this conference. So we'll miss all of them, and hopefully we don't have a list like that next year. I would like to introduce, for those of you who have not yet met him, the new judge in South Bend. And so Judge Paul E. Singleton is here. Thank you, Judge Singleton, for joining us. Thank you and welcome. I've gotten to appear in front of him twice already, and he's a delight in the courtroom, so I think you'll all enjoy. If you haven't been there yet with him on the bench, you're going to enjoy that. So welcome to our community, Judge Singleton, and we're looking forward to a long relationship with you. So, okay, CLE, I think we talked about. Virtual attendees, you have to fill out the form, send it to paul@pshale13.com. I mentioned that. I just want to give that out again. Please sign the form. If you're not vaccinated, please wear your mask when you're up and about. You don't need them at the table, but please be careful and be sure to do that. We have an evaluation form that's in the packet. We would ask you at the end of the business today to give an evaluation to us. If you want to make any comments, suggestions for topics, we really appreciate the feedback to help plan this for next year. We usually start a folder just about when this is done and start throwing in ideas, whether they're from the evaluations or from other things we think might be of interest. We like to start collecting relevant topics as soon as we can, so please do that. Also in your packet in the green folder, there's a half a page. We have a session at 3 o'clock that's Ask the Judge, Ask the Trustee. So this is your chance to ask questions. So we would ask that if you think of things, write them on the paper and try to get them. There's a box in the registration room, and we'd like to have you drop them off in that box. We'll pick them up over lunch and get them organized so at that 3 o'clock panel we can address your questions. Virtual attendees, if you've got questions you want to ask, your option is to email them. The email is ch13sbin@gmail.com. So it's like Chapter 13, South Bend, Indiana, ch13 sbin@gmail.com. If you email those questions, and I know about a third or 35% of our attendees this year are virtual, we will try to pick those up. And likewise, if you can get those to us by about noon or so, that would be great. Bathrooms are on the 3rd floor. They're marked out there. There's an elevator and stairs up. As far as the materials go, you should all have 2 folders, the green ones for the morning session, the manila colored ones for the afternoon. And so we'll pull those materials out as we go. Deb, what am I missing? Can you think of anything? We have it all covered? All right, so that's, I think, our introduction. I knew it wouldn't take quite as much time as we had allotted, but we can probably go ahead and proceed with the first panel. Is everybody here from the first panel already? All right, so our first panel is going to be service issues and the new federal rules of bankruptcy procedure. If you want to come on up, our panelists are Catherine Iskin, staff attorney for Deb Miller, Amy Gottschalk, she's a staff attorney in my office, and Lori Fisher, who's an attorney in Valparaiso, and they're going to walk you through the ins and outs of the service and the new rules. Thank you.
All right, good morning, everyone. I'm Catherine Iskin. I'm Trustee Miller's staff attorney. And next to me is Lori Fisher, and next to her is Amy Gottschalk, and we're doing the very exciting topic of service issues. So hopefully this will kind of be a bit of a warm-up for the morning. Hopefully it's a bit of a refresher for a lot of folks. So, and just as a bit of a disclaimer, when I talk about Lafayette service, I might say it's our cases. Again, the official transition isn't until October the 1st, so Trustee Rosenthal is the Lafayette trustee until October the 1st. So that's just a bit of a disclaimer for that. And turning it over to Amy.
Good morning, everyone. I'm Amy Gottschalk. I'm staff attorney for Paul Shale. We're going to talk about service issues this morning, including local rules and federal rules of bankruptcy procedure 7004. So first of all, let's talk about service of Chapter 13 plans. As you all know, when you come to your 341 meeting, we conduct the meeting, and if everything's good, we go ahead and conclude it. And at that time, then we file notice with the court that the meeting's been concluded, and the court issues an order. The order directs the trustee to, at least in Hammond, directs the trustee to go ahead and serve the plan. And I believe that's in South Bend as well.
That's correct.
So in any event, we go ahead and we send the information to Epic Service. Epic Service then serves the plan, the notice, and to everyone on the matrix of creditors, and then files a certificate of service. Excuse me. Now, where things get a little complicated or a little diverse is if at the 341 meeting you want to amend your plan, something's come up, maybe your client has decided that they want to keep that car, they don't want to surrender it after all, so you're contemplating an amended plan. In Hammond, it's important that you let us know that, because we will keep that 341 meeting open, and we will then go ahead and allow you the opportunity to amend the plan so that when we conclude it, we go ahead and we serve it. If we conclude that meeting, we're going to serve whatever plan's on file at that time. If you amend the plan subsequent to that meeting, you're going to be responsible then for serving that plan. So the order is going to come out, and it's going to direct the debtor then to serve that plan. South Bend, pre-341 meeting, post-341 meeting, the trustee will serve it. South Bend will direct the notice to the trustee to serve that plan, even if it's amended after the 341 meeting, but before confirmation. Now, for the South Bend cases, Trustee Miller's office does a little bit different. They do all their service in-house. They don't utilize Epic, so I'm sure there are concerns about that, and the timing and all that for that as well. So I guess the concerns are, what happens if the plan is improperly served? Well, first of all, we're not going to confirmation, and if we're not going to confirmation, we're not getting the plan confirmed. Attorneys aren't going to start getting paid, and nor are the creditors, and it causes a delay then in the plan being completed. So that will happen. Also, if the plan is improperly served because maybe creditors weren't named on the matrix, you've got an exception to discharge issue under 523A3. If those creditors are neither listed nor scheduled in time to file a proof of claim, they might not necessarily get discharged. So how could the plan be improperly served? Well, maybe it's untimely. We've seen cases where, the notice comes out directing the debtor to, or sometimes the trustee even, to get that served, and it doesn't get done within that time frame. So then another notice gets generated directing the service. It could be, like I said, the correct party is not on the creditor matrix, and I believe Catherine's going to go over that during the course of the morning. Incomplete address on the creditor matrix, Catherine's going to talk about that as well. And then those cases where the secured creditor or the IRS, the government entities, the federal depositories, they need additional service. That all needs to be done in order to either lien strip, cram down, those kinds of things. And I believe Catherine's going to educate us further on those.
So moving right along, we're going to talk about creditors that need just more notice than having an address on a mailing label. So the first kind of category of creditors that need heightened notice are creditors where you're determining secured status. So really what we're talking about is lien stripping and cram downs, usually vehicles. And also just in the back of the packet for this, there are full copies of the entire rules that we're referencing. So there's portions of them on the slides, but if you want to look at the full rule, those are attached in there as well. So the rule that's applicable here is Rule 3012, determine the amount of secured and priority claims. When we talk about a creditor that we're determining the secured status, you can do that in a plan filed in a Chapter 13 case, but you have to serve it in the manner of a complaint under Rule 7004. So again, that can be done in the plan. So Rule 7004 is the service rule. If you're stripping or cramming down a creditor who is a corporation, and that's your, Flagship Acceptance, Santander, those creditors, you serve it to the attention of an officer or managing or general agent, that kind of thing. And it's only by first-class mail. So as long as it's on the creditor matrix appropriately, attention to an officer, when it gets served out either by Trustee Shale's office or by our office, that is sufficient service. But it does have to be to the attention of an officer. So again, make sure it's on the matrix properly so that it gets served properly. So for example, and these are screen snips from actual plans that were filed. So this is someone who's cramming down a computer. So Dell Financial Services, attention President, CEO. Some attorneys go for the buckshot approach and just serve everybody highest ranking officer. So it's the second line of everyone. Every single creditor on the entire matrix is highest ranking officer. That's a good way to make sure you never really have that problem, is to serve everybody that way. And it is the debtor's responsibility to make sure that the matrix is done correctly. I don't really ever think that there's any finger-pointing type issues, but again, we do have a local rule that is applicable. It's the responsibility of the debtor to make sure that the matrix is filled out completely. So, and again, these are all for corporations. But when the creditor who is being impacted is an insured depository institution. And we'll get into exactly what those are later in this program. Those have to be served certified, addressed to an officer of the institution. There's some exceptions and they're noted there. But the main thing is that it has to get served certified. And a kind of quick and easy way to tell that is if there's the word bank in the title of the creditor, so Wells Fargo, Chase, Fifth Third, Huntington, those are typically a lot of the creditors that you see. So how does the plan get served in compliance with 7004H? Well, our service, in Trustee Shale's service, is first class only. We do not serve things certified unless it's something that we're doing in our office. So the debtor has to serve that, and typically it should also serve the plan or serve file the certificate of service of record with the court. So a lot of times what I see is they'll file either a supplemental certificate of service or a certificate of compliance. Again, this is from an actual filing, so we did a plan, we served the plan, debtor attorney is cramming down a car, he files a certificate of compliance, and then when it comes back, he files the green card of record with the court as well. Again, just proving that that service was sufficient. The next class of creditors we're going to be talking about is governmental claims. And so how do governmental claims get stripped in the plan? Well, the short answer is that they don't, because under Rule 3012, it's a request to determine the amount of a secured claim of a governmental unit can be made only by a motion or in a claim objection. And if you see the form plan, which again, the language is right there, it says for secured claims of governmental units, unless otherwise ordered by the court, the value of the secured claim and the proof of claim controls. So if you're trying to cram down the IRS, strip an IDR lien, that kind of thing, doing it in the plan is not enough to make it binding on the creditor. You have to do something else. So moving on to what something else we're going to do, Lori will take over.
Okay, let's talk about stripping a lien, either a governmental unit or a judgment lien in a bankruptcy. You really have three options. One, you could do it in your plan, you can do it by motion, or you can object to the claim, if it's just a regular creditor. If we're talking about a governmental unit, you only have two options. You file a motion or you object to the claim. But no matter which one you're doing, you have to make sure that you have claimed an exemption for that real property or the personal property. If you do not claim the exemption, you can't void the lien. So a lot of times, debtors' attorneys will just take the minimum amount of the exemption that it's been allowed. You need to make sure when you're filing your case, you go through and say, okay, let's say you have two parcels of property, so you're going to have to use the personal property exemption for your second parcel of property and can't use your homestead exemption. You need to do the analysis to make sure you're taking enough of the personal property exemption for that second parcel of property that you can now strip the lien or judgment lien that's attached to that property. You may have to forego taking the exemption on a car or household goods and items in order to take enough of an exemption so you can then void the lien. So let's say you're going to strip the lien by motion. If you're doing it by motion, that's a contested matter. So pursuant to 9014, the rules of service kick in under 7004. So you're serving the motion. Now, as Catherine showed, a lot of people are doing it with their plans and they put highest ranking officer P.O. box and just using the address provided for by the client on their statements. I don't think that's sufficient service. If you look at 7004, you need to address it to the institution, highest ranking officer, or comply with the state of Indiana service rules. Look up who your registered agent is. Serve it upon the registered agent address. Put that on your matrix. The other thing for practitioners is in order to make sure that the court is clear and the trustee is clear that you've properly served this, I would list that as your first address and not the alternative address. You know, when you go into best case and it asks you for the address of the creditors, sometimes you're just putting the one that's on the billing statement and then listing an alternative address as the highest ranking officer. I would list the service to ensure 7004 as your first address. So serve it upon the registered agent, because that'll print out on your plan so that everyone is clear that that's who's got served and that they are aware that they're getting stripped by your plan or motion. When I file a motion to void liens in order to be safe, I serve the registered agent with this on file with the Secretary of State of Indiana. I serve it care of highest ranking officer at their corporate office, and then I will serve it upon, if you're doing it by motion and they've also happened to file a claim, on the claimant, which is also required when you're doing an objection to the claim, that you serve it at that address. The other thing, well, on a side note here for practitioners on, it talks about 2002 motions to void liens, make sure you exempt the property. There's also a new rule that was added, 2002-3, which I didn't put on here, which talks about limiting notice, which the local rules have adopted a procedure in the Chapter 7 that says you only have to notice those creditors who filed claims in the case automatically. The federal rule provides that procedure also for 13. So if you're noticing, like in general, you have to notice all creditors of something, I would suggest that perhaps if you have like 100 creditors in your 13, try filing a motion to limit notice under 2002H to limit it to those creditors who filed claims. Also, the other practice pointer is that there's the new rule, Bankruptcy Rule 5009, that provides upon the termination of or completion of your case, you can file a motion to determine that a lien has been satisfied. That's another thing that you can do to ensure, on top of filing the cram down, especially with mortgages that you've sought to void entirely in your plan as being totally unsecured. I would recommend the way the rule reads is that you can do it upon discharge of the debtor. Now, the timing of that's, I've talked with Catherine about and Amy about, when do you do it? Do you do it the same time you file your verified motion for entry of discharge? Do you have to wait till the court has entered the order discharging the debtor and then file your motion? Should you wait till the trustee files its motion that you've completed the case? Can you file it then? So those are all issues that I'm not sure how the court would rule on, but at some point in time, you would be best advised to file the motion to ensure that your voidance, you have a separate order so that your client doesn't have to take to the recorder's office their order stripping the lien or their confirmed plan showing that it was stripped, that you have a separate order that designates the actual legal description of the real estate in the order saying this mortgage is gone. So you can void or strip a lien through your plan unless you're a governmental unit. Then you are required to file either objection to the claim of that governmental unit or a motion to strip the lien. In either instance, as Catherine went over, that requires heightened service. You need to serve at multiple addresses. One of the addresses would be provided by the list by the clerk's office, showing where you would serve the IRS, like at the U.S. Attorney's Office, that address. You have to serve it in Washington, D.C., and you have to serve it at the local level. There's also a provision that you should serve it upon the address provided in a proof of claim. Now, if you are stripping it according just with a regular creditor, again, you're back to the regular service requirements that you served like at the highest ranking officer. Serve it on the address provided on the proof of claim. And then again, I would serve it at a registered agent's office just to ensure that that all services provisions have been complied with. There is a local rule, 3007-1, talking about objections to claims. The court has made clear that you not only have to serve the notice, providing the 30 days time to object, but you also have to serve the actual objection to claim. That is a separate item that you have to serve upon the creditor via the service rules. So you have to serve the motion and the notice pursuant to 7004.
And we do have a required local rule here. You can get that on the bankruptcy court's website. I would hope that, I would hope this is a refresher, but here's the court's website. Go to rules and forms, local forms, notice of objection to claim. So if you're looking for it, it's pretty easy just to go to the court's website and download that. All right, so now the thrilling topic of how to properly serve governmental units. So who are we talking about here? Really, we're talking about the IRS and the Indiana Department of Revenue. Those are the two big ones. Occasionally, you'll have the Small Business Administration, HUD, other governmental agencies like that. So those do have to get served, again, at a higher standard than just, the place you send your check to in Kansas City. That happens. You should not be doing that. It does need to be by first-class mail, so it doesn't need to be certified. And it does need to be served at the U.S. Attorney, the Attorney General, and also the officer or agency. And the U.S. Attorney that gets served is your closest one. So, for example, here, this was a Fort Wayne case. This is, again, from an actual creditor matrix in an actual case. So it went to the U.S. Attorney in Fort Wayne. But again, if it was a Hammond case, you'd send it to Hammond, that kind of thing. And with the Department of Revenue, you don't just serve the Department of Revenue, you also serve the Attorney General's office for that. And also, again, just to make sure we're circling back to the local rules, there's a rule about how to properly serve those. So if you are doing any objections to claims or lien stripping, I would recommend just refreshing yourself with that. Also, when we were doing this, I learned a new thing about the court's website, that the court also is required to keep a list of all of the governmental entities and their service addresses. So this is right on the court's website under For Attorneys, and it has a list of federal agencies, state agencies, and the Department of Revenue. So if you're looking for that, you don't need to, do a Google search, try to find it. It's really very centrally located. It was a lot easier to find than I think it had been in the past. So that's a very convenient tool that hopefully you'll be able to use. And it's also under list of addresses, which is pretty self-explanatory. So next is serving an insured depository institution. And again, really that's just a bank. So anytime you see FDIC, that kind of thing. So those have to get certified on an officer of the institution. So, and I included this because the language on this slide because it's kind of confusing, and if you kind of chase the statutes back, it's like, is it a bank? Are they talking about credit unions? Do you have to serve like the actual person? It's not super clear. So this is something that, again, I personally served, and it's the CEO of Chase getting a letter from me in Columbus. So right there is the highlighted portion is how I served it, because it does say you have to serve it on an officer, not just the office, but the officer. Fortunately, though, there's a pending rule change that specifically says you don't have to serve the actual person to their name. You can just serve the office, like chief executive officer or president, that kind of thing. So I think it's nice because there is case law going both ways. I don't think we have any of that locally, but it is a concern So fortunately, that's not going to be a concern in the future. I believe that's the rules that take place in 2022, if I recall correctly. So when I personally serve something, and this is an adversary that has since been completed, it's been done for at least a year, I'll file the document, and then when I know that I need to get great service, what I do is I file the document, print it out, then I have Suzanne Hall, my paralegal, actually scan the front and the back of the envelope with the certified cards on those, and I'll file those as a supplemental certificate of service. Again, so there's no question that it was properly served. So that those images are actually there, they're on the docket, there's no question. And then, again, to steal Amy's phrase, if you're a belt and suspenders kind of person, when that certified card comes back, that gets scanned and served and docketed as well. And again, you can see the ECF stamp at the top, so you can see this is from an actual adversary that I did. Last kind of side note is about credit unions, and there's some question as to whether or not credit unions have to get served certified or whether they can just be served first class, particularly because Western Michigan has some case law that they have to be served certified. They're federally insured, so therefore they're federally insured depositories. Fortunately, one of the pending rule changes makes it very clear that those are only like FDIC actual banks, not the NCUA credit unions. So if you're stripping or cramming down a credit union, those do not need to be served certified. Those can just be first class mail, which is a nice change. Although that said, a lot of the creditors that might give your clients some hassle are credit unions, so it might be a nice thing to make sure that you do have that kind of heightened service so you can be sure that they got that. All right, so that is the portion of our segment on service. Does anybody have any questions about anything we went over or anything that we can help answer?
I have a question for someone out there. There was a Seventh Circuit case out there, in Ray Willett, which talks about valuation of real estate and when do you value real estate. They were, in that case, as if I recall the facts correctly, the court held that what happened was the debtors at the time of filing only had a life estate, a remainder interest in some property. During the pendency of the 13, they became now the fee simple holder and then filed a motion to void the lien because they did not file it at the time of the filing of the bankruptcy because they had no lien to void at that time. The Seventh Circuit held you valued the real estate at the time of the filing of the motion. So what happens now? You file your plan. You know you have a judgment lien out there. Or you don't discover it, let's see, until after you file your plan. The creditor comes in and files a secured claim. And the plan gets confirmed. You do your review of claims after the bar date and you discover it. Maybe it's a year later and you do your review of claims. Sometimes those slip by you. Your real estate's now increased in value. You file your motion to void lien. What value do you place on that real estate to void the lien? The value of the real estate on the confirmation date or the value of the real estate when you file the motion? Has anyone come across that?
I don't think that Paul mentioned it, but if you want to answer a question or ask a question of the panel, please raise your hand. We'll come and we'll bring the microphone to you. The only thing that we would ask because of COVID is please let us handle the microphone instead of you handle the microphone. But does anybody have an answer for Lori's question?
I mean, because if you knew about it at the time of filing of the case, and you file your motion there. Let's say you could strip the lien. But a year later, your property's now increased in value. You only took the minimum exemption. You didn't take the full exemption. What do you do? I mean, you're going to have to amend your exemptions now to take the full value, but you still have equity if you have to use the value as of the date of the filing of the motion. Yes?
Generally, in bankruptcy, the value of the property is the value at the time you file your case.
That's
So
right,
would-
but
so-
in Ray Willett says you value it as the time of filing of the motion.
Is that a district case? That's not a
Seventh Circuit case.
Seventh Circuit case, okay.
Thank you, Lorraine.
But the circumstances in that case were at the time of the filing, they did not have a fee simple. And so under 1306, the court said you value it because it's a post-petition asset at the day of the filing of the motion. So my question is, this isn't a post-petition asset. We had it as of the date of the filing. And everything else says you value real estate, the value upon confirmation. Does In re Willett change that?
You know, that sounds like a wonderful question for the Ask the Judge panel this afternoon. And if you write that down and get it in the box before lunch, maybe they might deign to answer it.
Okay.
Any other questions for this panel? Thank you so much for telling us about noticing. I know that I learned a lot. If we could give a round of applause, please. Now, the good news is, and since we started early and our next panel is actually virtual, you all have about a 15 to 20-minute break to call your office, do what you need to do, and then we will come back in at 9:40 so that we can have the update from the U.S. trustee. Thank you. Okay, we'll go ahead and get started. Our next panel is an update from the United States trustee. We're fortunate to have with us virtually Nancy Gargula, who is the U.S. trustee for Region 10, and also Susan Roberts, who is the assistant U.S. trustee for the South Bend area. I hope you'll help me welcome them, and they're a PowerPoint, and you can see Nancy and Susan over in the little pictures, on the right-hand side. So, okay, take it away.
Thank you, Deb. Well, good morning, everyone. I will be the first to admit that I am a bit disappointed that we are not there in South Bend with all of you, and to once again be presenting virtually. But David's travel and the attendance at gatherings of more than 10 persons. I'm hearing feedback that I don't know if you are, so hopefully you can hear me okay. I want to extend a special thanks to Paul Chale and to Deb Miller for not only continuing to hold this annual Consumer Bankruptcy Seminar, but also for accommodating our need to present once again virtually. I will tell you, it's been a tough 12 months since last year's seminar, especially with the unexpected loss of 2 of the region's Chapter 7 trustees, which of course includes Dick Ramsey. I first met Dick in law school because he was my bankruptcy law professor. And of course, after I became the U.S. trustee, I often kidded him that he really couldn't complain because he taught me I knew bankruptcy. Dick served distinction for more than 3 decades as a Chapter 7 trustee here in the Northern District of Indiana. He had a profound impact on the lives of so many consumers, and he is missed. Special thanks to Becky Fisher and Jackie Coleman for stepping in to help us out when Dick passed away. We also have 2 trustees in the Northern Districts of Indiana who have recently resigned trustee positions. Dave Rosenthal, who is as the Chapter 13 standing trustee in the Hammond Division at Lafayette more than 30 years, is resigning from his position next week as of September 30th. Dave's extraordinary contributions to the bankruptcy system and process during his tenure, highly valued, very much appreciated to best. The good news for me, all of you, is that we have 2 outstanding Chapter 13 trustees who continue to serve in the Northern District of Indiana, and we conferred with both of them. We were making the successor trustee decision. Deb Miller will be appointed by me as the successor trustee in all of Dave's pending cases as of October 1st. And Deb will also be appointed as the Chapter 13 trustee in all Chapter 13 cases filed in the Hammond Division from and after October 1st. Again, we really appreciate the assistance from both Paul and Deb as we work to find and the successor trustee determination. And just 2 weeks ago, Chapter 7 trustee Gordon Gabaya told me of his intentions to resign from his trustee position as of October 8th. So Gordon is going to spend the following months working to complete the administration of his cases. Gordon, too, has been an exempt trustee for over 30 years, who's administered thousands, distributed millions of debts to unsecured creditors, and helped preserve the integrity of the bankruptcy system. Gordon, too, will be missed, and I believe Gordon might be there. So thank you for everything you have done, Gordon. Earlier this week, I also learned of another trustee who plans to resign, but those details have not yet been worked out. So for those of you wondering, yes, indeed, we are recruiting for Chapter 7 panel trustees, and Susan will provide more information about that at the end of our presentation. And speaking of retirement, Congratulations to Judge Dees. Not sure he's there, but we would like to publicly thank him for his commitment to justice, his commitment to the bankruptcy process, and for his many, many contributions to the efforts of the U.S. trustee to protect and preserve the integrity of the bankruptcy system in the Northern District of Indiana during his many years of dedicated service on the United States Bankruptcy Court bench. And of course, we'd also like to say welcome to the federal family, Judge Singleton. So it goes without saying that every single one of us had to figure out how to continue working, how to do our jobs, so that many individuals and businesses that needed the relief afforded by the bankruptcy code had it available when the pandemic hit. You may recall that we initially halted about 60,000 341 meetings for about a month, all in order to keep everyone safe, that being our utmost priority, but also to give the U.S. Trustee Program an opportunity to figure out how we would be conducting 341 meetings going forward to continue to keep everyone safe. Conference lines for use by our trustees. We purchased hundreds of digital recorders so that trustees could conduct their 341 meetings from remote locations. We also work very closely with the bankruptcy courts and the bankruptcy clerks across the country to develop model notices for telephonic 341 meetings for both those that were rescheduled as well as new cases filed. I will tell you, the rescheduled 341 meeting noticing alone involved notices to approximately 1 million debtors, creditors, and counsel across the country. I'd like to acknowledge and thank Chris DeToro and his staff for all of their contributions and efforts as we worked through the rescheduling of the 341 notices there in the Northern District of Indiana, as well as helping us on the new form of notice. We developed protocols for conducting 341 meetings by telephone and for confirming a debtor's identification without sacrificing privacy and while still preserving the evidentiary value of the testimony. We also assessed alternative means that were proposed by some of our panel and standing trustees to conducting 341 meetings, most of which included a video component to assure that similar measures were in place. And since we resumed conducting 341 meetings in April of 2020, the majority of them have been conducted telephonically, with a few exceptions where we have some trustees across the country who are using the video platform, often in conjunction with a telephonic component, to conduct their 341 meetings. You may recall the U.S. Trustee Program issued a directive on August 28, 2020, so that we could all plan, and that is that all 341 meetings will continue to be held telephonically until 60 days after the declared emergency for the pandemic has been terminated by the president. So we'll have 60 days to reach out, work with our trustees, work with Chris and his staff, and obviously all of you will receive notice as well as we return to whatever the post-pandemic 341 meeting model and methods will look like. Now, every time I speak, the question is, well, what are we going to do going forward? So I will tell you, obviously final decisions haven't been made. We do have time because the pandemic, unfortunately, is still with us. But we have used this opportunity to take a look at the lessons learned during the past 18 months, develop best practices. We've looked at the advantages and disadvantages of how we've conducted 341 meetings while keeping everyone safe, to decide what it will look like in the future. We've also been consulting both internally and externally with various stakeholders in the bankruptcy system. And one of the options that is currently being considered is that all initial Section 341 meetings for consumer debtors will proceed remotely. And then the trustee or the U.S. trustee has the option to continue the meeting for either an additional remote meeting or a continued meeting that will be held in person. Obviously, the circumstances of each case will dictate how that proceeds. In addition, we're also reviewing the practicality of requiring that initial meetings be conducted by video instead of the current prevailing telephonic method. So on the likely assumption that post-pandemic 341 meetings will continue to be remote, we are also in the process of bolstering our current guidance to trustees governing how these meetings will be conducted so that we will promote consistent procedures and criteria for determining when meetings will be continued in person. So stay tuned for further updates on 341 meetings. And again, we're not going to make any announcements and final decisions until after the presidential emergency has been terminated. Let me move on. Speaking of the need to adjust what we did, the U.S. Trustee Program recently issued its annual report for fiscal year 2020, wherein we discuss our response to the pandemic, as well as the collaborative efforts that we undertook with our trustees and the various bankruptcy stakeholders in response to the pandemic. The annual report also talks about the remote audits that we conducted, our efforts in addressing underperforming consumer attorneys, which Susan will talk about a little bit later in our presentation, as well as other aspects of the work of the U.S. Trustee Program during what is perhaps the most challenging fiscal year we have ever had. And I know we're in good company with all of you in that regard. So we've included a copy of the U.S. Trustee Program's annual report for fiscal year 2020 in your handout materials for your information and reading pleasure. At the end of March, the U.S. Trustee Program issued a notice to all of our Chapter 7 and Chapter 13 trustees who serve in the districts regarding the treatment of both the recovery rebates as well as the increased child tax credits that were being received by consumers under the American Rescue Plan Act of 2021, which was enacted on March 11th. So by way of summary, first and foremost, perhaps most important to the consumers, is the fact that the recovery rebates are excluded from bankruptcy estates. Recovery rebates that are received within the 6 months of filing are also not being included in the calculation of a debtor's CMI. Recovery rebates are also being excluded from a determination of the projected disposable income available to pay creditors in a Chapter 13 plan. And finally, the expanded and/or increased child tax credit amounts are not being used by the U.S. trustee as we conduct our means test analysis in Chapter 7 consumer cases, nor should they be a factor in determining the projected disposable income in 13 cases. Our notice did not say anything about trustees not being able to administer tax refunds, and in fact, trustees continue to administer tax refunds as assets in their cases. So I want to share just a very brief update regarding PPP loans, which, as you know, are not available to any debtors in bankruptcy. The Consolidated Appropriations Act of 2021 actually provided for an amendment to Section 364 of the Bankruptcy Code and provided that when the administrator of the Small Business Administration made a determination and notified our director, Cliff White, that Subchapter 5 debtors, Chapter 12 debtors, and Chapter 13 debtors who are in bankruptcy are indeed eligible to receive PPP loans. However, the PPP loan program ended on May 21st, 2021 without the administrator ever making that determination. So therefore, no debtor in bankruptcy should have been approved for a PPP loan if the application, which is signed under penalty of perjury by the applicant, was completed accurately. Congress was busy, by the way. On Saturday, March 27th, the COVID Bankruptcy Relief Extension Act of 2021 was signed into law. And basically, this law extends many of the amendments to the bankruptcy code that were originally made under the CARES Act that would have otherwise expired on March 27th of 2021. So what that basically means is that the increased debt limit of 7.5 million for small business debtors who elect to proceed under subchapter 5 will remain in place until March 27th of 2022. It also means that these payments under federal law relating to the national emergency associated with the coronavirus will continue to be excluded from the determination of a debtor's CMI up through March 27th of 2022. And finally, that Chapter 13 debtors with confirmed plans who are experiencing a material financial hardship as a direct result of the pandemic can actually modify their plans to extend them up to 7 years. And that actually includes debtors whose Chapter 13 plans were confirmed after March 27th of 2021. One form of relief that did not get further extended was, of course, the moratorium on evictions. So I wanted to make everyone aware that the U.S. Trustee Program, in cooperation and coordination with the Department of Treasury, is currently working on an informational piece to raise awareness of the emergency rental assistance programs that are out there and available to individuals who are in or who are considering bankruptcy. And obviously, once that is available, we will get it widely distributed. In the meantime, I want to make sure everyone is aware that the emergency rental assistance programs have actually been around for a while, and they involve federal funds that are filtered down and distributed at the local level. So for individuals in the Northern District of Indiana who live in Elkhart County, St. Joe County, Lake County, and the city of Fort Wayne, they can apply for those rental assistance funds directly through those municipalities. For everyone else living in the Northern District of Indiana, the Indiana Rental Assistance Portal is currently accepting applications for the Indiana Emergency Rental Assistance Program. And these funds, if you're not familiar, actually provide up to 12 months in rental assistance to help cover both past due rental payments as well as ongoing payments, as well as utility payments for qualifying Indiana renters. There are also HUD counselors available to assist not just renters, but also landlords. So let me move on to another topic that really came to bear and to the forefront during the past 18 months, and that's cyber fraud. I will tell you, with most businesses operating remotely and everyone relying on email for communications during the pandemic, the fraudsters took full advantage to line their pockets with money belonging to others, quite honestly. The business compromise email scam was first identified in, of all places, the Central District of Illinois in Peoria. And of course, we've had many additional instances since then. So what happened in the Central District of Illinois was the perpetrators hacked into the computer system of the law firm. A law firm, of course, that did bankruptcy work and represented bankruptcy clients. So the perpetrator was able to readily identify the employee of the law firm who most frequently communicated with the law firm's clients. Sent an email to 3 of those clients, purportedly from this trusted employee, but really from the perpetrator, and basically said, hey, the trustees are now accepting payments online. So you can either have a Venmo account or you can set up a PayPal account. And if you don't have either, here are the instructions on how to set it up. So one debtor thought, I I already have a Venmo account, no problem. And unfortunately, the debtor sent a substantial sum to the Venmo account that he thought was going into the Chapter 13 trustees' receipts, but instead went into the pocket of the perpetrator. A second client's bankruptcy case hadn't yet been filed, and so that debtor just sort of set that email aside pending the filing of the case. And a third debtor didn't have a Venmo account, didn't have a PayPal account, followed the instructions on how to set up the account to a T, but before hitting send, decided to pick up the phone and call the Chapter 7 trustee just to make sure the account had been set up appropriately. And of course, the trustee's like, oh, no, I'm not doing online payments. The long and the short of it is debtor's counsel was contacted. The law firm brought in its computer security company. The hack was discovered. Our office, of course, was notified, and that resulted in notification throughout Peoria to all the law firms and the debtors. Well, as you can appreciate, with the 500 plus trustees who serve across the country and who administer Chapter 7, Chapter 13, and even Chapter 12 cases, the U.S. trustee program issued a notice alerting all of our trustees to this business email compromise scam so that they would also be on the lookout and on the alert. Since we issued that notice back in May of 2020, there have been a number of additional attempts, including some that were successful. So we have the claims administrator in a very large case that had its computer system compromised, and that resulted in several $1 million in funds that were intended to be paid to claimants in the case, instead being paid to bogus claimants. And of course, more than $3 million ended up in the hands of the perpetrators. We've had emails providing wire transfer instructions that have been intercepted with a couple of really, really close calls. The entire gambit of cyber fraud risks have been seen within the bankruptcy system, including several trustees who have fallen victim to the ransomware attacks that we have all heard about. So to protect yourself, make sure you don't share your passwords with anybody, including your staff. And of course, they always say use complex and different passwords for every account you've got. Of course, keeping your anti-software up to date and doing your regular backups are all very important. If you don't have cyber fraud insurance, you should at least consider whether you need it. And if you do have it, you might want to consider whether or not the amount should be increased. And this perhaps is the most important one, and that's make sure that your staff are aware of cyber risks. They shouldn't be posting anything about your work, your firm, your place of business on any social media site. They also, of course, shouldn't click on any links received from unknown senders. And they also need to very carefully look at the email addresses from those senders. Many of the infiltrations have resulted when the perpetrators change just one letter in the email address, because at first glance it looks like it's from a trusted sender, and it's not. So again, make sure your staff are equally aware of the risks. So with that, I'm now going to turn this over to Assistant U.S. Trustee Susan Roberts, who's going to provide some further updates, including in the area of top priority for the U.S. Trustee Program, and that's protecting consumers from the deficient practices of underperforming insurance. Susan?
Thank you, Nancy, and thank you again to Trustees Miller and Chale for allowing us the opportunity to speak to you all. I echo all that Nancy has said in our appreciation for our trustees and our thanks to Judge Dees and our welcome to Judge Singleton. As Nancy has mentioned, one of our top priorities for the program is the protection of vulnerable consumers. against deficient attorney practices. It's been a particular priority for the U.S. trustee program for the past 5 years, but it is specifically something that traditionally the U.S. trustee program has been concerned with. We have addressed a variety of deficiencies and issues involving consumer attorneys, ranging from attorneys who fail to accompany their clients to the 341 meeting of creditors to attorneys who have stolen money from their clients and everything in between. We have addressed multi-district law firms that advertise over the internet with their backrooms staffed with non-attorneys, and those non-attorneys are giving legal advice. This is a particular abuse that the program has great concern about, as it leads to the filing of cases that are often in the wrong chapter, where the information that has been gathered by the non-attorneys is not adequate for the understanding of what that debtor actually needs. We've addressed the value of the legal services provided by attorneys that fall below what the clients have paid for. And as new issues emerge more recently, we've addressed a variety of no money down fee arrangements. More on that in a couple of minutes. In FY 2019, the U.S. trustee program took more than 600 formal actions addressing misconduct by attorneys and non-attorney petition preparers. And the program continues to take action even during this pandemic, as difficult as that may be. Things that the trustee program has been able to do include conducting 2004 examinations of debtors via Zoom, seeking virtual information, obtaining documents, and so forth in the usual fashion. We've continued to attend court hearings, whether by telephone, by Zoom, or if it's allowed in person, in order to advocate for the rights of debtors. Included among our handouts is a press release issued regarding a recent settlement that the program reached with a multi-district business that also practices through the use of local partners, or what they describe as local partners, in various districts in the country, including in Region 10. That settlement addressed misconduct involving hundreds of Montana consumers, which came to light in the trustee program's investigation in 2 cases. The settlement, which is memorialized in a consent order entered by the Bankruptcy Court for the District of Montana on March 9th of 2021, resolved a number of issues. Among those were the delayed filing of bankruptcy cases, which caused harm to the consumers. So for instance, in a number of cases, the case would be taken in by non-attorneys. The debtors would pay over time, and often there would be more than a year, and sometimes as long as 18 months to 2 years from the initial hiring of that firm until a case was filed. During the pendency of the case, during the pendency of the retention and before the case was filed, a number of debtors, and particularly one where the motion was filed, were garnished, and judgments were taken against them. Garnishments proceeded from the debtor's wages, all during the time that the law firm was purportedly representing the debtor, but no case was being filed. So considerable harm was being done. In the District of Montana, there were clients who surrendered their vehicles to the out-of-state towing company that, of course, we know very well in Region 10, that towing company towed a vehicle all the way from Montana to Indianapolis and then auctioned the vehicle without proper notice to the secured creditor. The law firm misrepresented that it had sufficient number of local Montana licensed attorneys available to provide adequate bankruptcy representation to debtors whom it took in as clients. The firm misrepresented to clients the scope of and the cost of its legal services, and it failed to timely provide clients with written retainer agreements among some of the practices that occurred. Among the most egregious things that the firm did was to take in over 473 clients and collect fees from those clients. But only 109 of the clients that retained the firm had cases filed. And part of the issue was that clients who then sought refunds because their cases weren't filed or they didn't want the case anymore could not even get refunds when they requested the refund from the firm, or they would get only a very minor amount of a refund when in fact the firm had done nothing. No petition was prepared, no schedules were prepared, no case was filed. The settlement provides that the firm has refunded or will refund more than $300,000 in fees paid by Montana consumers for whom a bankruptcy case was never filed. The firm will pay a civil penalty of $10,309 and must return all fees totaling $3,770 to the debtors in 2 of the cases where the U.S. trustee brought enforcement actions. Additionally, in the case in which the debtor was garnished during the pendency of the retention and prior to filing, the law firm refunded to the debtor, compensated that debtor for the garnishment amount that were taken from the debtor's pay. The firm is currently barred from accepting bankruptcy clients or providing any bankruptcy services to consumers in Montana up through July 2nd of 2024. If you will recall at last year's seminar, Nancy shared details regarding the U.S. trustee's position on the bifurcation of agreements to provide legal services to bankruptcy debtors and fees. The U.S. trustee program reviews these practices as part of its duties, generally under 28 U.S.C. Section 586, and specifically in relation to Sections 329 and 526 of the Bankruptcy Code. As we know, under the Lamier case, which went to the Supreme Court, Chapter 7 debtors' attorney's fees cannot be paid as an estate administrative expense. And that's Lamier versus U.S. trustee, 540 U.S. 526, and that's a 2004 case. So to the extent that a model, a retention model involves a pre-petition agreement to pay U.S. attorneys, to pay attorneys' fees post-petition, the U.S. trustee program's position is that generally those agreements are subject to the automatic stay and discharge. And of course, the Seventh Circuit has the holding of Bethea versus Robert J. Adams and Associates. And the actual holding of that case was that a pre-petition agreement to pay attorneys' fees post-petition is an unmatured pre-petition claim subject to discharge. And in this district and in other areas in the Seventh Circuit, many attorneys have looked at dicta from that case, which talked about when, if at all, a bifurcated situation could be allowed. From the UST's perspective, models that involve bifurcated fee agreements raise other issues as well. The U.S. trustee does not take the position that bifurcation is per se illegal. However, indicia of misconduct that we look for include the failure to fully or accurately disclose the fee arrangement, lack of fully informed debtor-client consent, whether the amounts charged for pre-petition and post-petition services bear a relationship to the services actually performed pre- and post-petition. And this is particularly an issue where somebody uses a no money down model, as the attorneys will often charge the full standard flat fee under the post-petition contract, while apparently purporting to perform pre-petition services for free. That's probably a misrepresentation, and it results in an unreasonably high post-petition fee. The other issue that arises from that situation is that if an attorney is not providing services that are compensable prior to the filing of the case, then the attorney may not have actually met their duties under the code to properly evaluate the debtor's case, to do an appropriate investigation so that upon the filing, the attorney, when they sign the petition, their verification to the court that they have done that is not necessarily meaningful. Another concern is whether or not fees have been marked up to offset the cost of an attorney's third-party financing. This is a situation where the attorney, the vulnerable debtor, may really be being taken advantage of. Our position is that markups do not bear a relationship to the value of services actually rendered, and they are therefore unreasonable under Section 329B. There's a significant concern that the clients do not fully understand that they will owe a non-dischargeable post-petition debt when they sign up for a bifurcated agreement, or that the third-party factoring company may aggressively pursue the debtor to collect those fees if the client falls behind on post-petition payments. We'd like to ask you if you believe that your client has been harmed by one of these no money down fee arrangements. Please alert our office to that fact. One of our handouts is the U.S. Trustee Program Criminal Referral Report for FY 2020, and that is in your handouts. The U.S. Trustee is duty-bound under 28 U.S.C. Section 586 to notify the U.S. Attorney of matters relating to any action that may be a crime. The 2020 report reflects the 5 most common crimes included in the referrals made by the U.S. Trustee to the U.S. Attorney. These were tax fraud, which has been the most common crime referred for the last 8 years in a row, false oaths and false declarations, bankruptcy fraud schemes. These, by definition, are filings where there is nothing on the face of it that's wrong with the bankruptcy filings themselves. Rather, it's the reason why the bankruptcy case was filed that constitute the crime. Examples include an involuntary those were prevalent several years ago, and still we see them occasionally. Debt repair or credit repair scams, and other foreclosure rescue scams such as short sales. So be on the lookout for cases where there is an issue, an underlying issue for the reason why the bankruptcy case is being filed. Concealment is the 4th most reported crime or referred crime, and identity theft or the use of multiple or false social security numbers was the 5th most common in FY 2020. For debtors' attorneys, because debtors' schedules and SOFA, statements of financial affairs, are filed under penalties of perjury, and their testimony at 341 meetings is under oath, it is extremely important that you do due diligence to ensure that the information in schedules is complete and accurate, and that you advise your clients of the importance of providing you with complete and accurate information on all of the client's assets and liabilities. If you are aware your client may have been victimized, such as in an internet scam or a mortgage scam, please bring this to the attention of the U.S. Trustee. Nancy is now going to briefly discuss some of the crimes that have been identified in the Northern District of Indiana in cases that resulted in recent prosecutions.
Thank you, Susan. Before I turn my attention to that, I just have a couple of comments on what Susan has just shared with all of you. Obviously, we've gone over the top 5 most common allegations included in the referrals made by the U.S. trustees to the U.S. attorneys, but be aware that there are 43 additional crimes that were also included. And obviously, you know, as Susan mentioned, tax fraud is the most common and has been the most common allegation included in the U.S. trustee referrals to the U.S. attorneys for 8 years in a row. Well, that really should come as no surprise to anyone, simply because it's been, believe it or not, almost 16 years since debtors have been required to provide their tax returns to trustees. And as you can appreciate, our trustees have found a plethora of tax fraud as a result of the tax returns that have been provided to them, or in some cases, the tax returns that have not been provided because they've never been filed. So too the false oath and false declarations. Again, second most common 8 years in a row. Obviously, every document filed in the bankruptcy case is signed by the debtor under penalty of perjury, that the information is true and correct, and when it's not, that is a crime. And of course, all debtors testify under oath at their 341 meeting of creditors. So I just wanted to kind of underscore that for those of you especially who represent debtors. So be aware of those sort of common issues that could arise if your clients are not adequately prepared. So the U.S. trustee's statutory mandate is actually a shall. The U.S. trustee shall make a referral. And it's anytime I have reason to believe that a crime has been committed. And it's not just bankruptcy fraud, it is any crime. And it's not just a case that might be prosecuted by the U.S. attorney. It's any crime. So generally, I'm prohibited from discussing the criminal prosecutions of the U.S. Attorney's Office, but there is an exception. And the exception is if the U.S. Attorney has issued a press release and I have participated, then I am permitted to discuss. So we have included in our handout materials 4 recent press releases issued by the U.S. Attorney for the Northern District of Indiana during this calendar year. So one of the individuals prosecuted is a Chapter 13 debtor who was indicted on 3 counts of wire fraud relating to her Chapter 13 bankruptcy case, wherein she provided false information in her bankruptcy petition, and she also concealed, prohibited post-petition and preferential payments to a personal friend who also happened to be a creditor. It's alleged that this Chapter 13 debtor made post-petition payments totaling $40,000 on a brand new BMW vehicle that was purchased in the name of a limited liability company whose registration was the same address as this debtor's home residence. Among other payments that were made, all without the approval of the Chapter 13 trustee, who is Paul Chale, and without approval of the bankruptcy court. So this particular individual just entered a guilty plea on August 30th to 1 count of wire fraud, and perhaps most important for the integrity of the bankruptcy system, has agreed to pay restitution in the amount of $81,000 that will be paid to Paul for distribution to the creditors in this particular Chapter 13 debtor's case. The second prosecution I just want to briefly mention involves a bankruptcy petition preparer, often referred to by our office as a BPP. This particular BPP had been the subject of an enforcement action by our South Bend Office of U.S. Trustee, whereby we sought to have this individual enjoined from serving as a BPP. And indeed, the court entered an order prohibiting this BPP from serving as a BPP anywhere in the United States of America. And regrettably, as is often what we see, this BPP was not deterred in any way, shape, or form by the fact that there was a court order prohibiting her from continuing on with her efforts. And indeed, she did continue preparing bankruptcy documents for lots of individuals. She also induced her clients to lie about how much money they had paid to her. And this happens with some regularity, amazingly enough. This BPP filed her own bankruptcy case, and she neglected to disclose all of the income that she had received from the ongoing, continuing bankruptcy petition preparer services in her schedules. So in September of 2020, a grand jury handed down a 10-count indictment, charging her with 4 counts of making false statements in bankruptcy, 5 counts of subordination of perjury, and 1 count of making a false oath in her own bankruptcy case. In March of 2021, she entered a guilty plea to 2 counts of subordination of perjury in connection with the false testimony that she induced 2 of her clients to provide about how much they had paid her for her BPP services. Now, this particular individual's sentencing has been continued several times, but we do anticipate that she is likely to be sentenced in the not too distant future. One of the other press releases involves a former Chapter 13 debtor who was sentenced for conspiracy to commit securities fraud and ordered to pay restitution of more than $5.3 million. This individual was not registered as a licensed securities broker and went out and collected millions of dollars, most of which was used to support an enhanced lifestyle, shall we say. And regrettably for these investors, they found out when they were listed as creditors in this individual's Chapter 13 bankruptcy case. The fourth and final one I just want to mention involves a recent 29-count superseding indictment that was handed down in a criminal case in which 2 brothers are charged with multiple crimes related to their operation of a family dental practice. And included in the superseding indictment are 2 counts of bankruptcy fraud because, once again, one of the perpetrators filed their own bankruptcy case. So with that, I'm now going to turn it back over to Susan to talk about our recruitment for Chapter 7 trustees. And I'll give a spoiler here. We're also recruiting for a trial attorney in our South Bend office. So Susan?
Okay, thank you, Nancy. So going all the way back to the beginning, again, thank you to all of our trustees who have served so diligently and who have spent so much time and effort discharging their fiduciary duties and upholding the integrity of the bankruptcy system in our district. We are looking for 2 Chapter 7 panel trustees to serve on the panel, the Hammond Division, and 2 Chapter 7 trustees to serve in the South Bend Division. So our application deadline is October 18th of 2021. And you can find the public notice for these recruitments on the U.S. Trustee webpage at www.justice.gov. And you can also find links for the recruitment for the applications on the Bankruptcy Court's website at www.inb.us.courts.gov/UST-job-opportunities. And additionally, you can also find on our website and links on the Bankruptcy Court website to the trial attorney position. And we would encourage those of you who have extensive bankruptcy experience, or even not such extensive bankruptcy experience, but those of you who are dedicated to being in the system, to upholding the bankruptcy system, and to seeking justice for debtors, to apply for either the Chapter 7 trustee position and or our trial attorney position. We're very anxious to see good applicants, and we encourage those of you who are attending to indeed apply. And I'm going to turn this back to Nancy for our final words. Thank you.
And I just want to underscore a couple of things here. First and foremost, obviously the Chapter 7 trustees are appointed by the U.S. trustee. They are not employees of the Department of Justice. And I just want to make that clarification simply because the trial attorney position in our South Bend office is indeed coming to work for the Department of Justice. Now, I will tell you, and you can talk to any of our panel trustees, there's a lot of work There's a lot of work, but I think they have all found it to be very rewarding, as evidenced by the very long tenure of most of them, including Gordon Gabaya, who's done it for more than 30 years. Now, it's a bit ironic that Gordon is resigning his position because back in January of this year, the Bankruptcy Administration Improvement Act was signed into law, and that act establishes the Chapter 7 trustee fund. It amounts to a source of pay increase, the first our Chapter 7 trustees have had for no asset cases in more than 27 years. But it indeed is an opportunity for our Chapter 7 trustees to receive an additional $60 in their no asset cases, which probably doesn't even remotely come close to compensating them for all of the incredible work that they do. However, the Administrative Office of U.S. Courts, I know, has been working diligently to develop the systems for implementing the Chapter 7 trustee fund, because they actually issue the checks to our Chapter 7 trustees. So it's anticipated that these additional no asset fee payments will be paid out by the Administrative Office of U.S. Courts in early 2022, which means that the fee in a no asset case will increase from $60 to $120. So for those of you who are considering the application, I wanted everyone to be aware of that. And the other thing I want to say about our trial attorney position is that just like our panel trustees who serve for years, it's pretty rare for anyone to leave the U.S. trustee program. It is a fabulous place to work. It's one of the few places where, you do what's right. You carry out justice. And I know everyone who has joined the program has found that aspect of what we do to be very, very rewarding. So I will simply reiterate what Susan said, and that is we encourage all of you to please consider applying. So with that, we are actually at the end of our presentation. I believe we're a little bit early. Of course, we started a little bit early. So Deb, I don't know if there's an opportunity for questions. Otherwise, we are done. And again, thank you all for attending. And thank you, Deb and Paul, for accommodating and permitting us to present virtually. And hopefully next year, we will be there live and in person.
Thank you, Nancy and Susan. Does anyone have any questions for the United States trustee, the speakers on this panel? Not seeing any. Nancy, Susan, again, thank you so much for participating.
I can't hear you, Deb.
Oops, hold on a second.
I was going to say, I can't hear you. I'm sorry.
She's gone back to the.
I'm hoping
Okay.
I don't get feedback again.
Not yet. I can't hear you yet.
Thank you so much for coming and participating. I didn't see anyone that actually had any questions, so thank you again, and I hope you both have a wonderful weekend.
Thank you.
Thank you.
And for the panel here, please take a break of 15 minutes and we'll start our next panel. Thank you. Bye-bye, guys.
Have a good weekend.